Good day. Time to talk about property. Yeah, one of my favorite subjects. I think this is an important part. I think we do contract here in 7 or property here in 7 and contract law then in 8. And really, if I were to boil down, in my business life, I guess, what subjects I probably had to deal with the most, it would have been, property law and contract law, without question. Would have been those two. And so I think that, while we only devote a chapter to them, I think that they're really important for somebody that's going to get into the business world. And so at least we spend a little bit of time on it. And so let's take a look at that. I always said I should talk about the discussions and whatnot first, so let's jump in there. A couple things. One, I'm reading some of the comments are excellent. I would say I'm still not seeing as many as I would like to see, for a couple of reasons. I'm not seeing a lot of people necessarily outside the group submit discussions, even though it might end up being a valuable extra credit that some of you may want, as the semester goes on. Two, I'm seeing people go back. That's one thing, and I know probably as the semester goes on and you get a bad test grade or something, you're going to want to go back and post something to all those intending to get extra credit. And I'd like, for the extra credit to be of value to me, or for me to issue extra credit, keep it timely. In other words, do it in the week that's assigned or ahead of time. Certainly, because I've posted discussions for the next couple of weeks, and so you can certainly get in ahead of time, and that's going to be as valuable as doing it during the week of the discussion. But at this point in time, I'm not terribly interested in folks going, I'll read them, and I kind of enjoy them sometimes, but going back and adding something to the discussions that took place the first part of September, right? So try to keep it timely, if you would. That's what I'll take into consideration as I go through and grade the discussion. So keep it up, and again, I'd sure like to see more. Here, this one ended, right, December 27th, a total of 8 postings. Okay, if there was 5 people in the group, I maybe got one posting per person. One posting in, if it's reasonably well done, might get you an average grade. Okay, by average I mean in the 70 to 75% range. Okay, so I would encourage you to be a little bit more prolific, if you will, in your postings. On the other hand, one good posting that includes all kinds of information and those types of things could certainly get you a better grade than that. Don't get me wrong. I'm not trying to say I want you to post 20 things just because I'm going to look at the number and call it good. I read them closely, and the grades will be parceled out, based on both quality and maybe in some cases the quantity, with quality coming in first. Okay, quality is first. So if you post a really good posting that really adds a lot to the discussion, that maybe identifies some other sources of information, maybe a little personal bent on it is sometimes good too. If there's a personal case or something that's happened to you personally that relates to the case, yeah, that can be interesting and compelling as well. So yeah, please get a little busy. I'm a little bit concerned with this tail off that I'm seeing here in terms of the number of postings for those particular subjects. I'm quite concerned, as this counts for a reasonable part of your grade, so please get after it. So okay, onward then. Let's talk about property. I think your guys' assignment this time had to do with Kilo versus New London. Yeah, at least my name's not Gary or McAdams. Yeah, property is really everything, kind of boils down to property, whether we might own it or somebody else or some other entity owns it, right? Is that real property? Well, real property is defined as the real estate and anything permanently affixed. It becomes a part of. Well, I'm not going to want to move that outhouse there, so in my opinion, it's permanently affixed. Real property, yeah. The sign might be considered personal property because I don't know that that's a permanently affixed there. So, but the house is definitely, the vehicles would be personal property. Beer, personal property. There really was, I know the Michael Jackson most of us know of is the guy that did the singing and the moonwalk, but there was a Michael Jackson who wrote a column in Great Britain, and it was about beer. His job was to go around to the local pubs that they all brewed their own beer, and he sampled the beer apparently in reasonably good quantities, and then he wrote a column about it, and he passed away here. I don't know, it's been several years ago now, but it's a job I couldn't figure out where to send my resume, but it's a job I think would have enjoyed. But and I'll get in trouble. I'm probably not being politically correct towards rednecks. Bugger. Oh, once again, I'm picking on rednecks, but in this case, my wife had always wanted a riding mower, and so I showed her a picture of this and said I'd get her one for Christmas. She was not amused. I'm here to tell you, she wasn't amused at all. So, question: is it likely for a nation to be prosperous and maintain a vibrant market without having a strong concept of private property? If it is, I would challenge any of you to tell me that nation and the level of prosperity that they own. Truly the most advanced nations on our earth have some sort of private property, and probably the most advanced of the advanced have a very liberal or strong concept of private property, and it's well regarded in those nations. So the legal concept of property, yep. It's a foundation. It's like the rule of law and property kind of go hand in hand to set up private markets, free enterprise, those types of things that we in the U.S., by the way, take for granted. I don't realize that the 300 million people here are really a small fraction of the overall Earth's population, but we're privileged to have access to both private property and free markets and rule of law that has made us successful, and we just kind of take it for granted. We assume that maybe that's the case otherwise, and we've been luckier. Well, no, it's that our forefathers established this system, and it really has worked. So property means ownership, right? Who owns it, right? And there's exclusive rights in the resources, and of course we'll talk about that, right? It's one of those rights, of course, is the legal right to exclude or keep others from interfering, and for the most part we find that to be correct, right? We can certainly put a no trespassing sign up on our home and say we prefer not to have folks come and visit us. I guess we can do that, or probably not so much our home, but we see that more so maybe farms and ranches and those types of places, some of the wide open spaces that people would like to go at times, and there's some restrictions on that. So how do we the relationships among people concerning limited and valued resources, and the thing is we'll talk about that. In other words, how to what extent, and there's a lot of cases, to what extent can we exclude other people? If we control access to certain places, can we put a fence up? Maybe if there's public land on the other side and things like that. And so, what about streams, things like that? And so there's the issues are far more complicated than just saying, property is an absolute right, and we'll talk about some of those non-absolute rights. Okay, so the state comes into being to address problems of sometimes we have limited resources, right? Or the state versus private property. Yeah, I'm not sure that we'll spend a ton of time talking about that, but property is central to societal prosperity, right? Promotes incentives. Resources become more easily divisible, whether that's land, and let's not forget that property is not just real property, but it includes things like vehicles, money, grain, all types of different things are really property. Okay, and establishes conditions for capital formation. This one I find huge, right? Only if you live in a society that values private property is there a way or an interest really in the people to accumulate money, which then leads to capital formation. And capital formation is one of those key things that in a free enterprise system we have to have capital and make it available for those people interested in investing that capital into businesses or what have you that might provide goods and services then for us. And so it's a hugely important thing. I've been, when I was in banking, I'd been to conferences, and one of them, spoke about some of the issues in the Indian nations, and one of those with their land in trust. A lot of times it made it difficult for Native Americans to accumulate real property anyhow, and using that accumulation of real property is also a capital formation, right? That you can build up. If you own your own farm, you own the land and whatnot, and you need to go borrow some money to plant some wheat, you could use the farm for collateral, right? That's capital, the capital that you have. But if you don't, that makes it quite a bit more difficult, perhaps. And so, anyhow, the conferences I had attended, it said that that may be an issue that we have in Indian country about their abilities to prosper may be hindered somewhat by some of the restrictions that they have on real, especially property, but also maybe even private property. Private property certainly to a lesser extent. So divisions, right? You get real property, land, and interest in land, or things affixed to. And personal property is all other things, right? Typically movable. So real property again. This does require written agreements. When we talk about contracts and whatnot, we'll find out that written agreements are not always required. And it includes all fixtures. And we had a saying in the banking that a fixture was anything that a 150-pound man with a 5-pound hammer couldn't remove in 5 minutes. If he couldn't get her done, then it was considered a fixture. So that was just our saying. It's not a basis in law, so don't write that one down. It won't be on the test. Okay. Personal property, on the other hand, is just property that's not real. It can be movable, tangible, things like a car, bike, trailer. Intangible are other interests, right? Things that maybe don't have a physical form. Okay, like interest in insurance policy, think patents, trademarks, copyrights, those types of things, right? So, though property is a right and there's some exclusivity involved with that, it's not free from restrictions. And why is that? Well, you wouldn't want your neighbor, if you lived in a residential area, to build a chemical incinerator right next to your house. Okay, that might be a little bit disturbing, right? Or if you lived, in a nice neighborhood, you wouldn't want gal that just bought the one in the middle of the block to open up a cat house, maybe if you had children and those types of things. And so there's restrictions, on the use, because we have to balance some of that with the needs and wants and desires and of other folks, right? Okay, so we further break down property, and we talk about things that are maybe common property. I'm going to tell you these are my examples. But things that aren't necessarily owned by either the public or the private. And I put streams in Montana because Montana, I don't know if it's unique by other states, but Montana's law regarding streams and stream access is that the water that flows down actually belongs to the people. Okay, so even, if and looking at some of the water things that we've seen, in the discussions, a couple of discussions about that, if water's flowing through my property, okay, that's actually considered, the water itself is considered to be owned by the people, and while I own the property, that which flows through it needs to be made accessible to everybody. And so in Montana, yeah, if there's a flowing stream, you have every right to access the stream, and up to the high water mark, really your actions can't be inhibited. Okay, and well, I shouldn't say that. Your legal actions, can't be inhibited. I mean, you can't go pollute and do things like that, but you have a right to go there and fish and check it out, do whatever, collect water samples or something. Okay, and so I've deemed that to be like a common property, and then we see common property or open source types of things on the internet too, and I put Linux because it was an open source, and there's some other open source things out there that people use that those things I think then become kind of common property, owned by no one, owned by everyone type of thing. Okay, then we got public ground, state government lands, things owned by us as taxpayers and whatnot, and then private ground, which individuals, companies can own, right? I didn't even know there was a Houdini Picture Corporation, old Harry Houdini. Apparently, after all his antics of escapes and those types of things, actually started a picture corporation. So you could have bought stock in that. And your ownership, and represented by the stock certificate, would have been intangible in that case. Those are personal items of property. I'm talking about the pickup and the boat and whatnot. The guy's still in there. It's amazing. These guys look pretty unconcerned. Yeah, he's got his arms crossed. He's BSing with the guy next to him. They don't look like they're terribly concerned. I think I'd be a little nervous. Yeah, I'd be a lot nervous. Okay, how do we acquire it? Best method, of course, is gift. What could be better than having somebody give it to you? Exchange is what we talk about in business all the time, right? We exchange, we barter, we exchange money or something else perhaps for property, and so that's probably the most common way that we acquire property is through exchange. Accession means that we're adding to something that exists, and so if I think the book says if we have an engine and we build an airplane or a car or something up around that engine, then the things that we've added to it we own through accession, right? Because we owned the engine to begin with. Confusion, and the book talks about fungible assets, and fungible assets are those things that can maybe get tossed into a pot and stirred up, and then you don't know whose was whose when it went in, and maybe it doesn't matter because the objects are similar enough. And in this country, you could imagine grain, for example, that happening, right? Two farmers drop off a load of grain at the elevator, and the elevator doesn't mark whose is whose and gets them mixed up. They're each going to get a proportionate share, right? And how you're going to figure out who had the higher protein quality and those types of things, higher weight, I don't know. But it's fungible in that you then become a part owner of the whole versus an owner of your little half. And so adverse possession, that's an interesting concept where you can actually obtain ownership of land in a sense by simply occupying it. And I think we talk about that a little bit later, but that can happen actually in more cases than you believe. But imagine boundaries maybe not being as precise as we'd like them to be, and so you build a garage and it happens to stick 2 feet over the property line into your neighbor's property line. and it's there for 30 years. Maybe your dad built it before you, or your grandfather, right? So it's been there for 30 or 40 or 50 years and nobody said anything about it. And then when the neighbor goes to build something or whatever, he has a survey done and they figure out that, oh my goodness, okay, that's 2 feet over. Well, can your neighbor ask you to tear the garage down? Well, they certainly can ask, but might you have to? Maybe not. You know, that's where the adverse possession comes in, because you've had it there openly and notoriously, and always thought maybe the property was yours. You may, with just compensation, actually be entitled then to ownership of that. First possession, original possession, kind of similar things. I think first possession talks about, well, if you're the first one to come across a meteorite, because it's brand new, right, to Earth, then by golly, you're going to be the owner. And it might apply to some lost types of items too, where you might reduce it to ownership. And an original possession, I think, is similar. I think original possession might deal more with the copyrights, trademarks, those types of things. Those are property as well. And if you're the creator, patents, right, you might be deemed to have original possession. So I got ahead of myself. Exchanging, we talked about that already. First possession, maybe inventors, creators. In Montana, there's a law about lost property, and I believe the law says if it's a value, and I think it's $20, but don't quote me on that. But you know, if you find a nickel or a dollar even on the ground, you're under no obligation to go through the efforts of trying. In fact, I found 3 cents on my run this morning, 3 pennies by golly, and moved up my retirement date by a couple seconds. So anyhow. If you find something of value, though, you're required to make a reasonable attempt to find the owner of that. And then if after a reasonable attempt that owner can't be located, then you might be reduced to the owner, who might become you, which would be a first possession thing in that case. I think it's 90 days, and I think you have to make a reasonable effort, which might mean advertising the property, things like that. So adverse possession, I already talked about again, right? You think about the garage thing, right? You had the garage there, it was open and notorious, you weren't trying to hide anything. Your ownership of that was actual and exclusive, just as if it was your property. It was improper, however, it was continuous, so it had been there for quite a while. It was for a period of time. And so you might well be granted, you know, rights to that. Another example that we'd see in our parts too might be roads. You know, again, say your grandfather has owned a piece of property maybe or he owned it, and then your dad owned it, and maybe now you own it. It's been in the family for 80 years, but your neighbor has consistently driven through that property on a 2-track road to get to some of his property that otherwise might be inaccessible or difficult to access. And you and your neighbor get in a little pissing match, and you decide to shut that off. Okay, your neighbor may have an ownership right. Okay, your neighbor may, because same thing, he's openly and notorious. He's actually and exclusively, you know, occupied that in a sense, occupied it in that he used it. Okay, for a period of time and continuously. You know, he may be granted an easement because he's always had it. I think they call that an easement by prescription, if I'm not mistaken. Easement by prescription. Eminent domain then is the public's right to condemn and take property for the good of the people. It does require the FMV, means fair market value remuneration, so payment has to be you know, made if you're going to take somebody's property like that. There has to be a physical invasion of the property, and there has to be a loss of all. This is a key, okay? When you look at some of the cases, you know, like I think I maybe have you looking at Kelo versus New London, and the local case is Kafka's case, and that all is a key word, okay? Acquiring property through confusion, and we talk about fungible, right? Already kind of talked about that. And, we talk about gift, and again, when we get into contracts and stuff, there has to be intent. Okay, there has to be intent, and there has to be delivery, and that's where, you know, some of the issues come up, of course, in wills and those types of things, or gifts that take place just before a person dies, and really creates issues. And intent and those types of things might be one of the issues that really gets discussed. ownership of real property, and this is important. I hope you guys really study this and get this down, because it's really important. First, ownership can be otherwise known as estate, and the most simple, the one with no conditions attached, is called a fee simple, absolute. Okay. On the other hand, you could have fee simple defeasible, meaning that there's conditions attached. So it might be set aside for conservation. Might have, most subdivisions have conditions set. The restrictive covenants, they might be called, right? And that might be conditions that would be attached to the real estate. Talking about the type of home that has to be built. It has to fit some sort of a standard, and those are okay as long as they're fair and equal and they're not discriminatory, etc. Okay. A life estate can be kind of popular, right? Conveys property until the end of a person's natural life. And we talk about a reversion interest, right? The property will return to the original owner upon death. So let's think of a situation there where perhaps my mom, she's getting a little bit older, and I told Mom, I said, well, I'll buy you a place to stay. Okay, I'll buy you an apartment or buy you a condo or something, let's say. And we'll have a life estate, okay, and you'll get to live in the place, and you'll pay the taxes and the upkeep and do all that on it, but then when you die, it would come back to me. That would be a reversion interest in that case. Okay, a remainder interest would be kind of the opposite, where maybe mother has some property and she decides that she wants to make sure that property comes to her kids. Okay, and so she might then say that here, you're upon my death, then you'll be entitled to the property. Or a lot of times might be used too in charitable cases, where if you wanted to leave your property to a charitable cause, perhaps on your death, okay, you could do that as well then, where you would sign the property over to them, but you would retain a life estate. Okay, so you'd have access to the property, you'd get the income off the property, and you'd be responsible for the expenses, but then upon your death, it would automatically, the remainder interest would go to whatever that charitable cause is. The future interest, somebody that has a future interest, some person or entity, is said to have a future interest if they have either reversion or the remainder interest. So if you're the one that's going to get the property upon somebody's death, you have a future interest. Leasehold is also a type of ownership, actually, right? Right to use a property for a specific purpose and a specific duration, but let's not downplay that. It is a type of ownership, okay? And many of us have entered into leasehold, and you have rights, right? That are ownership types of rights when you're in a leasehold situation. That could be for an apartment, for a dorm room, what have you. There can also be conditions on that too, no pets allowed, right? Things like that. We're still, in this case, we're talking about real property. Okay, we're still talking about real property here. And we're talking about ownership of real property and how it's oftentimes held. First is tenants in common, and tenants in common are, I think the important thing is it's most often used with unrelated parties. So my partner, or my buddy, and I, we own some land, right? And we own it as tenants in common. Now we do have equal shares, but it could be unequal. It could be 60-40 or 70-30. And we own it as tenants in common because we both want to make sure that if something happens to us, the property then would pass on to our heirs or assignees. Okay, and so that's typically what we would use as tenants in common. Now, we would use joint tenants in some cases if we had, generally if we were related. Okay, so we'd have joint tenants, and that may work too then if I wanted to make sure the land went to him, okay, my partner. Yeah, okay, maybe not as likely. The most common for married or for married and maybe children and those types of things is joint tenants, right, or survivorship, where then you put that, and it just says that right on the deed. Usually it says JTROS, and it means if something happened, then the property automatically goes to the survivor. okay, or survivors if there's, say, more than one. Okay, and so there can be joint tenants, and I believe it can be more than one. Joint tenants up here could be more than one too, and it's equal shares. I think typically if you're unrelated, you'd still use the tenants in common, and here, joint tenants you might do if you're related. Okay, conveyance of property, warranty deed. Warrants property to be free of encumbrances other than those noted. So if you're buying property, you always want to request a warranty deed. You want the seller to warranty to you that that property is free of encumbrances other than those noted, because there could be encumbrances on there. It might include things like easements or those types of things, easements for power lines or phone lines, things like that. Okay. Fairly common when you're purchasing. A quit-claim deed, on the other hand, transfers property without warranty, and that's often used with family transfers. In fact, I'm working on one with my mom, actually. She needs to transfer property from her name personally into a trust that she has created. Okay, it's going to be a quit-claim deed, right? Because she doesn't need to warranty to the trust that it's free and clear of encumbrances. You know, it's really from her to her is what it amounts to, and so we can file a quit-claim deed. And so they're usually used for simple transfers like that. If spouses get divorced, you know, and one spouse is required to sign over their interest in the property, it usually is done with a quit-claim deed. Okay. If you left property or gave property to a child or something, you might do a quit-claim deed. Okay, again, it's simple, simpler. You're not warranting anything, so the person's taking that property as is, and it might have some encumbrances on it. So, and in Montana, transfers are recorded in the county. I would guess that's probably the same with most states. So, when we use real property as collateral, there's a few things, a few ways we can do it. Generally, if we're talking about bigger farms, ranches, those types of things, we use mortgages, and that's for bigger than 40 acres. Now, what happened is mortgages and the ability to foreclose on a mortgage is a fairly cumbersome project, and so at some point in time, states kind of, you know, banks and whatnot, and even the owners, because owners of houses and whatnot wanted to be able to get into homes a little bit more easily, and it was in the government's interest to make that happen. And so what they came up with, a way to get people into homes easier is to make it easier for the banks to foreclose if a person defaults. I know that sounds kind of weird, but kind of, would that be idiosyncratic maybe, or I don't know, not intuitive, that's for sure. But anyhow, it's true, and so banks and people really lobbied for ways to purchase smaller tracts. Homes is what they were gearing for here. That would be a little bit easier, and so they set up, and there's not a lot of difference between a trust indenture and a deed of trust. Okay, but really what that's saying when it's done is that if you're financing that, okay, then the land is held in trust, whether it's a trust indenture or a deed of trust. They're really kind of synonymous. It's held in trust until the conditions were met or the loan's paid off, right? And so really a third party is sort of technically holding that in trust, but you have all the obligations and everything if you're the buyer, right, to pay the taxes, do the upkeep, do those types of things. But then when the land's paid off, then it's conveyed from the trustee to the person that bought it. Now, if the person defaults, say on the loan or the obligation, then the trustee can be instructed to give it back or deed it back to the original owner, okay, the seller in that case. So, or the financer, I'm sorry, could be the not necessarily the seller, but the person that financed or provided financing for the purchase of or refinance of the place. So it made it a little bit easier than for foreclosure than actually going through a mortgage foreclosure. So limitations on property, right? We have limits, and again we talked about those because we don't want things. We don't want bars next to high schools. We don't want bars next to churches, and so we've enacted some limits on those types of things, right? Okay, so it's subject to the rights of others, right? and private property can give away to the good of society, and we talk about that in terms of eminent domain, and taxation is required on property for benefit of the good, right? I was just reading a deal where Haver wants to increase, the city's taxes, the property taxes within the city, a pretty decent chunk. Now, looking at it, for me, it's probably going to be about $400 per year in order to pave and improve the streets in Haver, which are, as most people would say, are probably desperately in need. Okay, we can have a nuisance, right? And nuisance was one of the original ways where people enforced other rights, so meaning if your neighbor was polluting, maybe your neighbor took his garbage out every morning and just threw it on your side of the fence, right? Well, that's a nuisance, and you could sue, right? And so your neighbor doesn't necessarily, or your neighbor's making too much noise, at 1 in the morning, okay, setting off fireworks at 1 in the morning all year round. Well, yeah, it's an unreasonable use of property, right? And so it can be a nuisance that basically you can sue for then in that case, okay? Almost can be called a trespass. So zoning, it's kind of an exercise of police powers, right? We go back to the police powers where we say states have the right to enact laws for the benefit and general welfare of their citizens, right? And so we allow zoning to take place and regulation of land through the zoning, right? Limits can be to the use of or the aesthetics of, and use, again, we get back to in Montana, you can't have a bar next to the schools, and you can't have a bar within a certain number of feet from a church. Okay, and we've done that because we've said, we want those places to be free of that distraction. Okay, and aesthetics. I can remember when we were on, I was on Hilton Head Island one time, and you're driving around, and I think Whitefish is like this too, by the way. You're driving around, and you don't see the signs that stick up above the trees to tell you where the next McDonald's is at. And as you're driving around, you know that there aren't any signs sticking up above the trees, and so you ask around a little bit, and you find out that no, there's a limit as to the height of the signs. Okay, and that's important. They decided for the aesthetics of Hilton Head Island to improve and make more valuable the property on the island for everybody. Was it effective? I don't know. Pretty valuable the property was. Variances apply to the ability to get maybe some of those limits reduced or taken away. And I've seen variances used in town, maybe where a person wanted to build a garage, and the setbacks, or the law says, according to the zoning law, says that you have to be, at least 8 foot back from your property, but when you get ready to build it, you find out that the only way that the project works is if the garage is within 4 feet of the property line. Okay, and so you can go and you can request a variance, and you can say, hey, I understand that that's the law, but it's not going to affect anybody, and in fact, here my neighbors have all signed off that they're in accord with it and they're in agreement, and so could I be granted a variance? And the city can grant that. Then the governing body at the city, whether it's at a committee or the city as a whole, can grant those types of things. Restrictive covenants can be put oftentimes on development. So think of a developer. There's an addition in Havre. It's right up next to the hospital. It was called the Centurion Addition, and when it was originally formed, the developer said that every house built there had to have a value of at least $100,000. Yeah, and the idea here was that they wanted to establish this as a fairly nice residential area. Back then, $100,000 was a lot of money, by the way. That's quite a while ago, where a $100,000 home was a big deal. Today, it's a shack, right? But in the past, some of those covenants were really nasty. I mean, they were very discriminatory, if you might think back, 50, 60, 70, 80 years ago, where they had restrictive covenants, and they would completely exclude certain minority groups, etc., right? And so they were a real blemish, and for a while they were allowed to do that, and of course the laws have changed and we can't do that, but there can be building restrictions, height. There was an interesting battle that happened down in Great Falls a couple of years ago, where there was I believe it was a restrictive covenant. It might have been zoning. So I mean, the two can be kind of similar. It just really depends on whether the city or county established it, or whether it was established by the developer. In this case, it was zoning, because the gal or gals had gone to the courthouse and asked about the zoning for this area where there was a lot for sale. And they were assured that the zoning would fit their needs, and so they actually went ahead and purchased the lot. What they wanted to do is they moved a double wide or a modular on there. Well, when the neighbors saw that going in, they protested, and they said, "Wait a minute, it's zoned for only, stick built, or not, modular or whatever." And the gal said, "Yeah, but we checked with the city," and so it was a big fight. And I don't remember what the resolution was. Okay. But you could have those types of, the restrictive covenant could certainly say also, just like zoning. Again, I think it just kind of depends on who created, the covenant. But it could say, no mobile homes, no, those types of things are okay. Again, as long as they're not discriminatory. Have to be careful there. So, what's an easement? An easement is the ability to cross, right, pass over somebody's land or property. That's granted, and they're really more common than you would think. It was very unusual, actually, to see a property description for a warranty deed that didn't include exclusions for easements or provisions for easements. So think about all the power lines. They all have easements. All the gas lines, all the sewer lines, all the water lines, all those things have to have easements, okay, in order to take place. Roads, okay, are oftentimes easements. Okay. Sometimes the roads are owned by the city, don't get me wrong, but sometimes where they go, they have to cross some private land, and so they get an easement. Okay, and so that's fairly common. Okay. Bailments is, that's why we call bail, I guess, because we place goods into another's possession to be returned in the future. Pay somebody to store it and watch over it for us, right? Okay, could be something what a bailment is, right? Eminent domain, the Fifth Amendment, government taking private property for public use. And I think if you read the kilo, you'd be unusual if your reaction isn't a little bit harsh and say, God, how could they do that? How could they take somebody's property for that purpose? And I think I provided another article. I hope I did. If not, I'll try to, or you remind me, I'll surely provide it for you, that a legal professor from Missoula had written a really nice kind of response to that. And when I read that, my initial response was harsh, but when I read the professor's explanation, my response was a lot more muted. And come to find out, the Supreme Court really said in that kilo argument was that, you know what, if the state had a law that prohibited that, it could have been prohibited. And it turns out in Montana that we do have, laws that probably would have prohibited the same type of thing that happened in Kelo versus New London. So, but governments can take private property for public use. It's the public use part that I think gets most people, because we think oftentimes public use as being roads and those types of things, and we all agree, it makes sense that the government should have the right of eminent domain, that if they need that property to build a road, they should be able to take it, but they should have to pay, just compensation, and maybe that compensation will have to be determined by a third party. Okay, we all believe that, but what happens when, like the kilo, a company comes in and says, we would like access to this land. We'd like you to get rid of all these old tenements or whatever, and we're going to put in a big, beautiful new car dealership or something. Should that be allowed to happen? Should the city then? But is it a public use? Is it going to benefit the public? Well, maybe. New jobs, those types of things. So those issues are getting to be pretty interesting. You could probably find, I know there was some websites I've seen in the past, it's been a few years since I've looked at them, but like eminent domain abuses or whatever, you might Google it and find some really interesting and compelling stories, right? So can real property or property itself be taxed? And certainly, I think I told you, Haver's looking at trying to raise taxes to fix the roads. Education, and we all want law enforcement, we want courts and national defense, although our national defense comes from our income taxes, but, right? And that comes from the 16th Amendment, right? Okay, and so taxation, well, that fits in the property thing, because I guess your income is probably considered property, right? Because once you've earned it, it becomes property of yours, and can it be taxed? Yeah, as long as it's for a reasonable purpose, Secured transactions, okay, applies to personal property and how those things are used for collateral, right? You can buy a car and you can use the car for collateral, right? And the the bank files a lien against that, right? Okay. It doesn't, cars have titles, and so do like mobile homes, and so those are fairly easy. But what if it's other property that doesn't have a title to it? Yeah, we did, of course, a lot of financing with farms and ranches and whatnot. So you filed what was called a financing statement, and you would have, if it was in order to purchase that, you'd have a purchase money security interest, which has a priority if it comes to repossession. Okay. And that's sometimes you have to identify that if you end up having other debts then that occur, and maybe other people get attachments or judgments or those types of things, which I think we talked about in the prior chapter, right? Garnishment, maybe it was a couple chapters ago, we talked about garnishment and execution and obtaining judgments and those things, right? Okay, and so having a priority is kind of a key. And so if you finance a proper, or let's say a car, okay, and it's titled, and you're the lender, you can get a pretty good priority interest. But I can tell you this: if a mechanic does work to restore that vehicle to operational, that mechanic's actually going to have a priority interest, simply because of their duties or their function or whatever they did to get the car up and running. The car would be valueless probably if it wasn't running, and so they're given a priority. Okay. And so, priority problems, I guess I'm telling you, is kind of one of those gray areas. Sorry, there's way too many of those in law, but there actually are specific, while it's gray, there are fairly specific orders that things go into as to who would get priority in the event of certain actions. Okay, just understand that they vary from transaction to transaction and item to item. Secured interest that are recorded first in time always take priority over competing interest recorded later. I just said no. Mechanics, artisans liens, those types of things actually could, mechanics liens or artisans. I'm trying to remember what some of the adjusters liens, those types of things can actually take some priority. Imagine living in a society where you, as an individual, had little or no right to own real and personal property, had no rights. Wow. Yeah, that would be interesting, wouldn't it? So there's property. It's a good subject. It's a good chapter. It's in depth, but I hope that you all kind of enjoy it. It's something that you're going to have a part of your whole life. Okay, whether you even end up in business or not, it's going to be an important part of your life. So please pay attention to it. Thanks, and we'll talk to you next week.